Hello, I'm Cliff Ely. I represent injured workers in Colorado, and I've been doing it for over 25 years. Today I want to talk to you about final admissions of liability. If you received a final admission of liability, please listen to this very carefully, because if you do nothing, your case will close. A final admission of liability is filed by the workers' compensation insurance carrier after the authorized treating physician has placed you at maximum medical improvement and assigned a permanent disability rating. Maximum medical improvement is defined in the Colorado Workers' Compensation Act as the point where no further treatment is expected to improve your condition. At that point, the doctor gives you a disability rating, and then the insurance company usually files a final admission of liability and mails it to you and the Division of Workers' Compensation. It will show what has been paid in lost wage benefits to you, and those end at maximum medical improvement. It would also show your impairment rating and how much that is worth. Remember, even a 0% is an impairment rating. So if your doctor says you have no impairment, he's given you a rating, and the insurance company will put that in the final admission. The insurance carrier also has to state a position on if they will pay for medical treatment beyond maximum medical improvement. Remember, just because you're at maximum medical improvement doesn't mean you don't need medical treatment. You often need treatment to keep you at that level, and the insurance company has to note on the final admission if they will pay for continued treatment. If you want to keep your case open, you have to do something within 30 days of the date that the final admission is mailed to you. So look at the mailing certificate, it'll have a date on it. If you don't do something in 30 days, the case will close on that final admission. And this is what you have to do. First, you have to file an objection to the admission. The form you need for that is attached to the final admission, and it's also available at the Division of Workers' Compensation website. The form should be filled out and sent to the insurance carrier and the Division of Workers' Compensation within 30 days of the date the final admission was mailed to you. But you have to do more than that. If the final admission admits for a whole person rating and you can test that rating, you need to go through the Division IME process and file a notice and proposal to select an independent medical examiner. There's more about that on my website and in another video on Division IMEs, but that has to be done within that same 30-day period. If you can test that you're at maximum medical improvement, you also need to go through the Division IME process. Now, if the insurance carrier denies ongoing medical and you want those, or if you have an extremity rating and you think it should be higher, or if you think it should be converted to a whole person rating, then you don't have to ask for a Division IME, but you need to file a hearing application within those same 30 days. And if you have any other issues, you should put that on the hearing application as well, or the case may close on those issues. For example, if you think that your average weekly wage is too low, you need to put it on the hearing application. Hearing applications can be found at the Colorado Office of Administrative Court's website. If the insurance company thinks your rating is too high, it can also ask for a division independent medical exam rather than file a final admission. If they do that, you'll receive a document that shows that they filed for a Division IME. As you probably concluded, this is a very complicated process and one that you should not go through without at least getting the advice of an attorney. If you have any questions regarding final admissions or any other workers' compensation issue, call me at 303-785-2828. I'd be happy to answer any questions you have at no charge and to provide you with a free consultation.